as read by Senior State Attorney Americ Smith. Above all, I have looked at the law as cited by all counsel in this matter. I got instructions limited to identifying sureties whom the applicant proposed to court from the trial judge. This is linked to the administrative function that registrars are clothed with. Identifying sureties is to compare what is on record already as sureties with the actual persons in court. This practice has been long in place. It's not an invention by the trial judge today in this matter. To require a registrar to conduct identification of sureties. It's one such aspect that occupies registrars and occupied me while sitting as a registrar. Quite some time. This is done not only in application for bail, but also in the application in administration causes where applicants are seeking for letters of administration. Neither is a registrar goes with authority to grant letters of administration or to hear such an application, just as in bail application. Yet in all instances, the trial judges have often authorized registrars to conduct identification. In my view, the identification of sureties does not amount to a hearing of an application, because the sureties have already been identified in the pleadings and in the submission. There is no illegality that is being condoned, which is clear by the prosecution. The response is submission. This is the practice that court has in accordance with section 43 through the KIA on registrars conduct identifications. The role of this court here aims at satisfying court that indeed what was reported by court under the pleadings, also motion and the applicant, and the submissions is what the applicant is presenting. With all the above said, this court proceeds have identification of sureties in this application conducted. And so order.
Most obliged, Your Honor, I just don't remember that I can challenge the ruling of this honorable court. I just want that to be most obliged.
Your Honor, will require a formal judgment that has been directed by the ruling of the court.
Go ahead. Please come forward.
Those are the small. That's the order.
Yes, that's the one. The Azilisse, the first shoot, and the followed by H of the alphabet. You know that all the documents in relation to those switches have been submitted to court.
Council, are you watching?
Station case number 309 of 2024, Uganda versus Alliance Jamari, Alliance Control.
I'm not aware that they are his persons. However, his legal representative is here. The circumstances, I pray that the accused demand that he had under production warrant. But his legal representative is also.
No, Your Worship. Explanation there.
Your Worship, we had not brought them because of space, but they are in the cells.
And the cells.
Yes.
Councilman, have you started with the matter? Or is
Worship, the reason we am Cadet Principal Officer Fred Kenya. Yes, Lord. Cadet Principal Officer Frederick Kenya. Yes, Lord. Let me confirm, Your Worship.
You have been had.
We are confirming, Your Worship.
Whoever is addressing the court in this matter should be what we enough and on microphone. What was it the first time?
Most of them. Tonight please you worship. Robert Bautu. I'm appearing jointly with Honorable Mamadi Seleko. Mr. Mpima Jamil. Karuba Eno. Kainj Ivory. And Awero Susan. Awero Sarah. Excuse me, Your Worship, I know you refer to as Susan, but her name is Susanna. My Lord, Mr. Amarit Timothy.
Let me pronounce
Most of them.
my Lord, my name has been murdered, so I prefer to give it life.
All the judging authorities.
Also, like, my Lord, my name is Timothy Amerit. I am the Honorable Senior State Attorney in the office of the DPP. I appear together with Counsel Zubeda and Namugeni. I beg your pardon. Counsel Zubeda and Namugeni. From Sania Namugewan Company and Force. My Lord, the applicant is in court. And this matter was coming up for hearing by the learned judge. In his absence, my Lord, I prefer another day.
Your Worship, we've appeared in this matter several times. The first time we appeared in this court, Your Worship, the court gave us directives. Those directives were to the effect that the applicant will file submissions.
Now, the time to proceed in this manner. The history of the matter is known even to the prosecution.
Most of them.
You
Your Worship, we're going to move you under that particular provision of the law, but if you're giving us most of that.
The local judge indeed is not available this morning, but he has given directives that we have the securities identified and any other matters shall proceed thereafter. So that's the position and that's how we are going to proceed.
Your Worship, could we add that on the issue of identification of sureties, we could also highlight, since it's for purposes of receiving?
No. Highlighting of submissions?
Highlighting just a few segments of the...
I'm not close to that office. I want to hear take particulars of the securities period. Those are the instructions, and that's where the legal mandate is.
On that note, Your Worship, then would move to identify the sureties as directed by Hajjat.
Your Honor, yes, Timothy Americ. Yes, Your Honor. We appreciate the information that we have received. I need, however, to bring to this honorable court the fact that the hearing of this matter is not an issue of convenience, but one of law. And I've well noted that this honorable court will not take on the hearing of the submissions, which perhaps will be done later. Your Honor, that in my view can subsequently be done with the identification of the sureties in the subsequent sitting. Your Honor, under Section 15 of the Trial and Indictment Act, it governs the hearing. Under Section 15 of the Trial and Indictment Act governs the hearing of a bail application and release of the accused person on bail. And it clearly states that that mandate is squarely of the High Court, and in this instance, the judge sitting as the High Court. The consideration of the bail application, Your Honor, consideration of the bail application, Your Honor, includes one, the applicant lodging the application, the respective counsel either divine being heard on the application, the sureties being identified by the court, and certainly the subsequent determination of the application. the law requires that such undertaking be handled by the judge of the High Court. The sureties in this matter. However, in the interest of maintaining the integrity of these proceedings and legitimacy of the application that has been filed by the applicant, it is only in the interest of justice that either the matter is adjourned until the availability of the judge to entertain it, or recourse can be sought from the head of the division or any supervisor to have this matter reallocated and heard by any judicial officer who is available. Otherwise, we shall suffer a fate, the applicant will suffer a fate where several applications will arise to be determined, pending even the determination of his own bail application in regard to the legitimacy of the proceedings. It is the applicant that will suffer. I really want this matter disposed of as quickly as yesterday, but in the right way. In the right way. I so pray, Your Honor.
Submissions of the Land Council and Land State Attorney, Senior State Attorney. Firstly, to note, Your Worship, is that the court is not making a determination in this matter. The court is not sitting to determine the matter. Those are very key, important issues to note. The court has specifically stated that it is here to receive on the sureties for identification as directed by the trial judge. Your Worship, I want the court to note trial judge. The trial judge is ably known in this matter. And my land friend has considered ably that the trial judge gave directives. Unfortunately, he is not here either on health grounds or other grounds, and has issued a directive to that effect. It's unfortunate, it's baffling that my land Senior State Attorney, who has practiced before this court, cannot appreciate the administrative nature of these courts. Your Worship, the land Senior State Attorney has stated that Section 15 of the TIA enjoins the court to hear bail applications in the High Court by a judge. We do agree that that is the position. However, Your Worship, you're not sitting in this court to hear the bail application. In fact, the courts, as near as possible, have always adopted the procedure under Section 14 2C of the Judicature Act, in as far as
14 what?
Section 14(2)(c) of the Judicature Act. In circumstances where there is no proper procedure and the court is enjoined to promote good.
Can you read the section?
Most of it.
Let's use of the microphone.
That section, Your Worship, is to the effect that where there are no express law or rule is applicable to any matter in issue before the High Court in conformity with the principles of justice, equity, and good conscience, the court is enjoined to adopt a procedure that aims at promoting equity and good conscience. Your Worship, the directive by the land trial judge is in conformity with this particular provision. And indeed, Your Worship, it has been a practice of this court where the court, under that particular provision of the law, directs the registrars to either identify or receive passports in case the bail application has been concluded, or enforce the directives of the land trial judge. It is in conformity with that particular provision. Your Worship, it is a fortified submission that you're ably in charge of the directive of the land trial judge. You're not sitting as a court to hear the bail application. And indeed, as the land state attorney has stated, section 43(2) equally enjoins this court to give such directives in order to achieve the ends of justice. Your Worship, the land state attorney has relied on the case of Bravo Enterprises to claim that this is a matter where you're sitting as a registrar to hear the matter. We disagree first and foremost. In the Bravo Enterprises case, Your Worship, the registrar entertained certain matters when he did not have jurisdiction. He had determined, and the Supreme Court said, no, you do not have such jurisdiction. This is not a matter where the court is hearing. This is not the matter where the court is saying the sureties are substantial. That is not there. The submissions of my land state attorney should have arisen at the time of an appeal, in case he wants to appeal, that you entertain. Your Worship, it is on that ground that we invite you to proceed and entertain the receipt of the sureties. My land colleague, Mr. has something to say.
If may please, Your Worship, I would like to emphasize section 43(2) and read it in verbatim, that talks about officers of court. And it states as follows.
Section
43(2) of the Judicature Act. 43. Subject to Article 133 of the Constitution. the officers of courts of judicature shall perform such duties as may be assigned to them under the rules of court, and shall be subject to general direction and supervision. And also 43.1 states that there shall be such officers of courts of judicature as may be necessary in performance of any such special duties in connection with the business of courts of judicature. And such officers may include the chief registrar, registrars, deputy, etc. Your Worship, when we are here, state can also attest. Just a second.
I just want to get clarity. The provision is reading, I want to be sure that we are in sync of the provision. Because the 43 is reading is not the 43 I see in the 7th revised edition. I just wanted to maybe clarify that. We seem to be reading different laws.
It's clear here that where in any case no procedure is laid down for High Court by any written law or by practice.
Council, what section are you reading? Because your colleague that wants to ascertain.
Section 43
Of the laws it is.
of the laws it is, Your Worship. And in any case, Your Worship, my learned colleague clearly stated that this court has adopted a practice in applications, and would like to say that you're seated here as court, not in your own capacity or from your own volition. And you stated that immediately you had entered. Your Worship, you clearly stated that you're here to identify. In any case, we already made submissions that you clearly stated were already a record of court. And they associate themselves to those submissions because they have theirs in reply. Meaning, Your Worship, that even a mere giving of date, he will object because you're not, in his opinion, the trial judge. And he would say that that would be a fault in procedure by his own assertion and submission. In our opinion, Your Worship, you're here in the rightful capacity, and we invite you to perform your duty as assigned to you as court. Most obliged.
Your Worship, just one thing, because the Land State Attorney relied on Rebuttal enterprises versus URA. Your Honor, first and foremost, of course, that was equally a civil case, but this court equally is enjoined under Order 51 of the Civil Procedure Rules to entertain interlocutory application. Your Worship, we are not saying you are entertaining an interlocutory application, but this is an interlocutory application that you are equally mandated under Order 51 of the Civil Procedure Rules to entertain. Because this is a bail application arising out of the main case. So, Your Honor,
I don't want you to play us, just to call it this way.
most of it. So, Your Honor, it is our submission that just like how the court gives directives to you to adjourn matters, these directives are in sync with you to receive the sureties that the court has decided. The trial judge has not divested himself of the powers to entertain and determine the application for bail. That one is not irrevocable. Secondly, the trial judge has not directed you to determine the substantiality of the witness of the sureties. The trial judge's directives are very clear. Receive the sureties. And Your Honor, that is a noble duty that everybody should be in position to appreciate. First and foremost, the documents are already on record. In regards to the sureties, the land state attorney replied to those documents. What is here is specifically to identify the sureties that the court has never had occasion to look at.
Can we have a rejoinder?
Your Worship, if you so wishes, but I don't think that it has that.
I'm also obliged, Your Honor. I believe the submission that this Honorable Court under Order 51 of the Civil Procedure Act has powers to entertain this application. Your Honor, it was on record. I prayed to make
And I said it's not very important. It is not going to be very important.
Well, Your Honor. Your Honor, this matter has been captured in the report.
And it can be captured as it is very important.
Your Honor, I don't mind that you don't report it, but I feel that I still bring it up. Most obliged. My brothers submitted that this Honorable Court by Order 51 copy letter, and we shall know what each person said. So my brother has argued that this court is merely hearing, not determining. And he further stated that the court is merely hearing from the sureties who are already on record. How can court determine if in the first place there was no hearing? You know, just the thought of it, it doesn't make any sense. By this court as it's sitting, receiving the particulars of the sureties in the record, that in itself amounts to hearing. Whether it determines the application or not is something else. And that is the integrity of this application that we seek to have maintained. The entire process of it. By hearing the sureties, getting their name, getting their residence, getting their phone number, getting their national ID details, that in itself is tainting the application in its entirety. And we want to arrest that abuse. And there is no doubt, once an illegality is brought to the attention of court, court must not close its eyes to it. My senior brother, the Honorable Nsereko, said that I had said, and I wrote it verbatim, that I had said that this court has in the past adopted the practice in applications. I did not make that submissions, far from it. And there is no practice I brought to the attention of court that has been adopted before. Your Honor, there is a very big difference between a registrar appearing in a matter such as this and adjourning, then appearing in a matter as this and receiving particulars of sureties. When a registrar sits and adjourns a matter, the registrar is not hearing the matter. But when he goes ahead to entertain and get information that informs the determination of the application, that is a hearing of the matter. Which cannot be tolerated by this honorable court. A section was read, section 14(2)(c). And I would first want to read it verbatim and I make an explanation thereafter. Section 14(2) says, subject to the Constitution and this Act, the jurisdiction of the High Court shall be exercised A, in conformity with written law, including any other law in force. Then when we jump to C, where no express law or rule is applicable in any matter in issue before the High Court, in conformity with the principles of justice, equity, and good conscience. No express law or rule is applicable in a matter in issue before the High Court. When the law says before the High Court, it is talking about before a judicial officer entertaining, lawfully authorized to entertain the matter. The High Court is not seated here. It's not. We cannot say these proceedings are proceedings of the High Court. They aren't. As far as this provision is concerned. So this refers to the High Court sitting. And it says that the principles of justice, equity, and good conscience. What does justice require? What does equity require? What does good conscience require in the instant case? What does it require? What does justice require? The man is rotting in prison, he needs to come out. But we are not going to illegitimize his application. He needs to come out. And I'm okay with him coming out, but in a proper way.
I'll see to that, Your Honor.
So what does justice require? What does equity require? What does good conscience require? In a division like this, where there are other judicial officers, what is too hard with another judicial officer today hearing this matter, one authorized by law, today? That would be justice, that would be equity, that would be good conscience. What is too hard with that? Let Mwizera have his day before a judge and have his application determined. No, my Lord, counsel, you are not going to divert me. I am responding to section.
It shouldn't be restricted to what we stated.
I'm responding to section 14(2)(c), and that is what was raised.
Your Worship, we need some order in this.
My brother, please do not distract me. For your record, I cannot be distracted. For your record. Most obliged. And I request my brother respect and decorum.
And I very serious English, we really respect.
So my brother, verse 6, it's my day. What does the principles of justice require? What do the principles of equity require? The best that this court right now can do is either adjourn this matter till a judicial officer that is authorized appears to handle, or Your Honor, seek supervisory intervention to have this matter reallocated before any other judge today, and we have this matter disposed of today. I retaliate my earlier prayer.